Introduction. I got your attention with this silly Brandon's blog title, didn't I? The answer to the question, will Julian Assange face Canadian bankruptcy laws, is of course, no. He may face the justice systems of Britain, Sweden or the United States, or all three. But as far as I know, he isn't wanted by the Canadian authorities. However, there are many Canadians having problems paying all of their debts. Many have actually quit satisfying their financial commitments. If this is where you find yourself, then you are in financial difficulty and may even be insolvent. I tell everyone that bankruptcy should be your last option. There are many ways to avoid bankruptcy. It really depends on how early on in your situation you consult a professional for advice and guidance. The purpose of this Brandon's blog is to answer what seems to be the 10 essential problems bothering people thus far in 2019 for people facing financial challenges and considering filing for bankruptcy. What happens if I declare bankruptcy in Canada? When you declare bankruptcy, you must assign or hand over your assets to the licensed insolvency trustee, previously called a bankruptcy trustee, trustee. Each province regulates what assets are exempt from seizure. So in bankruptcy, you will not lose all your assets. There is a listing of things that are excluded from seizure in Ontario. Necessary clothing for you and your dependents. Home furnishings and appliances that are of a worth not more than $13,150. Tools and various other personal effects not worth more than $11,300, made used to earn revenue from your business. If you are an Ontario farmer, this amount increases to $29,100 for everything, including your livestock. One car or truck that is worth not more than $6,600. The cash surrender value of life insurance if your beneficiary is what is called a designated beneficiary. Your registered retirement savings plan, RRSP, registered retirement income fund, RRIF, or deferred profit sharing plan, DPSP, other than for any amounts contributed in the 12 months immediately preceding your date of bankruptcy. $10,000 of equity in your home, but only if your share of the equity is less than $10,000 in total. Earnings are not impacted by bankruptcy, yet you will need to submit a monthly income and expense form providing your household revenue and expenditures. This becomes part of your budgeting procedure. If your earnings go beyond specific criteria developed by the Office of the Superintendent of Bankruptcy, OSB, you will certainly have to pay part of the excess into the bankruptcy estate via the trustee. This is called surplus income. When you declare bankruptcy, the assets that are not exempt from seizure must be turned over to your trustee. Those assets will be offered for sale and the cash gained from the sale of your possessions will be available for the trustee to pay a dividend to your creditors. Also, see below the discussion of will you lose your house and car in bankruptcy, as these assets may be handled differently. How much does it cost to file bankruptcy in Canada? The irony is that it does cost money for an insolvent person to file bankruptcy in Canada. The cost of a no asset, no surplus income bankruptcy is in the $1,800 to $2,000 range. If you have neither assets nor income, then you or someone on your behalf will have to make satisfactory arrangements with the trustee for payment of this cost. If there are assets and/or surplus income, this will most likely change the calculation of the amount the trustee is entitled to charge for administering your bankruptcy. However, the trustee is entitled to take the court-approved fee from the funds obtained through the sale of assets and/or the surplus income payments received. In this case, the cost of your bankruptcy to you may very well be no extra charge. Will I lose my house and car if I file bankruptcy in Canada? A complete discussion of the issues involved can be found in my April 2019 blogs. If I file for bankruptcy Ontario, will I lose my home? 2019 edition. Can you file bankruptcy and keep your home and car? 2019 car edition. The trustee is entitled to your equity in your home and car when you file for bankruptcy. As these other blogs discuss, if someone can purchase the value of your equity, subject to the Ontario exemptions, then the trustee will not have to take possession of your house and car. Can you file bankruptcy and keep your credit cards? The issue of a bankrupt keeping his or her credit cards is governed by Section 158A. 1, of the Bankruptcy and Insolvency Act, Canada, BIA, and Directive No. 3 issued by the Superintendent of Bankruptcy, OSB. The title of Directive No. 3 is, Duties of the Bankrupt to Deliver Credit Cards to the Trustee. It is provided to define under what conditions a bankrupt shall supply to the trustee, for cancellation, all charge cards issued to and in the ownership or control of the bankrupt. In all conditions, the trustee shall require that the bankrupt supply to the trustee, for termination, all credit cards issued to and in the ownership or control of the insolvent person with one exception. Except for those bank cards discussed in the next paragraph, in a bankruptcy, all credit cards must be given to the trustee. This is regardless that there may be a zero balance on that charge card. There is only one exception to this requirement. The insolvent person need not supply to the trustee a credit card in the possession and control of the bankrupt where the primary cardholder is a third party, for example, employer, spouse, friend, parent, and the primary cardholder has obtained a supplementary card in the name of the insolvent and about to be bankrupt person.